A landlord tapes a single page to the door of a Florida business. 3 days later, that business can be on a legal conveyor belt moving so fast that by the time the owner calls the lawyer, most of the exits are already welded shut. Residential tenants of Florida get warnings, protections, and second chances. Commercial tenants get almost none of that. And there is one statute, one paragraph buried in Chapter 83 of the Florida statutes that wipes out nearly every defense a business tenant has before they ever see a judge. I call it the Registry Trap. Stay with me because I'm going to show you exactly how it works and the one move that keeps you in the fight. So all right, let's get into this one. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. Now, I've spent decades litigating commercial lease disputes in this state and on both sides of that taped-up notice. And what I'm about to walk you through is the actual machinery of a Florida commercial eviction. Now, here's the first thing every business owner needs to understand. Florida law splits Chapter 83 into two completely different worlds. Part 2 covers residential tenants. That is where you find the tenant protections people assume exist everywhere. Part 1 covers non-residential tenancies, your retail space, your warehouse, your office, your restaurant. And Part 1 is a different animal entirely. I call this the commercial speed gap. The legislator decided that businesses are sophisticated parties who negotiated their own leases, so the safety nets disappear. No required repairs by the landlord, no retaliation protections, no grace built into the system beyond what your lease gives you. But here's the thing. The speed gap is not the dangerous part. The dangerous part is what happens after the notice hits the door. Under Section 83.20 of the Florida statutes, when a commercial tenant fails to pay rent, the landlord serves a written notice demanding one of two things within 3 days: pay the rent or hand back the keys. I call this the 3-day trigger. Not 30 days, not a negotiation. 3 days. And now you're probably thinking, 3 days is impossible. My receivables are slow. I just need a week. Well, the statute doesn't care. The reason why landlords move this fast is simple. Every month a non-paying tenant occupies the space is a month of lost rent the landlord may never recover. Florida law hands them a fast lane, and they use it. Now, your lease can change this. Some commercial leases require a longer cure period. Some require notice to a guarantor or to your lender. The reason why you pull your lease out the moment the notice arrives is that the lease, not the statute, may be hiding your extra time. But if the lease is silent, the trigger runs on the statute's clock. And what comes next is the part almost no business owner sees coming. It is the moment that decides the entire case, and it happens before any hearing. Now, if you're getting value from this, hit like and subscribe because the next 2 minutes can save your company. Now, when the 3 days expire and the rent is not paid, the landlord files an eviction lawsuit. And here's a contrast number 2 with ordinary litigation. A normal Florida lawsuit gives a defendant 20 days to respond. A commercial eviction proceeds under what is called summary procedure. You get 5 days. I call this the 5-day window. Weekends and court holidays complicate the count, which is exactly why the worst thing you could do is let that summons sit on a desk while you figure things out. But the window is still not the trap. Here's where it gets brutal. Section 83, 2.32 of the Florida statutes is the most unforgiving sentence in the entire body of law. When a commercial tenant wants to fight an eviction, the tenant must deposit the rent that the landlord claimed is owed and rent as it keeps coming due into the registry of the court. Not into your operating account, not into your escrow with your own lawyer, into the court's own registry. And listen to what happens when the tenant fails to do this. The statute treats that failure as an absolute waiver of the tenant's defenses. The landlord becomes entitled to an immediate default for possession. No trial, no hearing on your brilliant arguments about the leaky roof or the broken HVAC or the landlord's own breaches. The courthouse door closes and the sheriff's writ follows. This is a registry trap. You're thinking, wait, I have to pay the disputed rent just to earn the right to dispute it? Absolutely yes. That is exactly the rule. Florida designed commercial evictions as pay to play. The legislator's logic is that money sits safely with the court while the parties fight instead of disappearing into a failing business. Whether you think this is fair is besides the point. It is the law, and it eliminates the leeway commercial tenants assume that they have. So stop doing what most business tenants do, which is ignoring the notice, hoping the landlord is bluffing and calling a lawyer on day 6. Instead, here's the sequence that actually preserves your options. The moment the 3-day trigger lands, read your lease for cure periods and notice defects. A notice that demands the wrong amount or is served improperly can be challenged, but only by someone still standing in the case. If the lawsuit gets filed, respond inside the 5-day window. And if you intend to fight, get the rent money positioned for the court registry, because the Registry Trap does not forgive good intentions. Landlords watching this, the same speed that protects you punishes sloppiness. A defective notice can reset your entire timeline. So now you know the 3 mechanisms that make Florida commercial evictions the fastest game in civil court. The 3-day trigger, the 5-day window, and the Registry Trap that ends cases before they even begin. The businesses that survive are the ones that move within hours of that notice hitting the door, not days. Now, if this video opened your eyes, hit that like button and subscribe. I break down Florida business law so you can protect your company before the crisis, not after. I'm Santiago Cueto, your Florida business attorney. Now watch this next video where I break down the litigation framework steps to defend and protect your company.